think reasonable people can disagree about the merits of digital markets regulation, but I think certain aspects of the bill are beyond that reasonable disagreement. I think as things stand, the bill is designed in a way that maximizes the CMA's ability to bring infringement decisions. But that's not the same thing as maximizing outcomes for consumers, right? More decisions doesn't necessarily mean better outcomes for consumers. The areas that are problematic, the biggest area is the very limited judicial review of decisions, and it is judicial review in this case. There's a sense when you read the bill that procedural safeguards and limits are seen as a bug, not a feature, when in fact it is precisely these things that ensure that regulators adopt decisions that ultimately benefit consumers. There are a couple of other, there are other issues.
Stick with that just for a second. But I mean, the counter to the argument you're making, and we've heard it already, but the counter to it is that in the UK, other regulators also operate under JR appeal system.
Yeah, but I think in this case, here's a way of putting it. You've got two different models of regulation. One would be something like competition law, and you give the regulator an extremely broad scope of what it can do. When you give that broad scope, what you want to do is to at least have some kind of counterweight, which could be stronger full merits review. On the other hand, you could have a bill that's extremely tailored and has only certain very limited provisions, and then maybe you'd be fine with judicial review saying, look, the bill is extremely clear, there's no sort of common law of this bill that needs to be fleshed out, and we'll go with judicial review. The problem with the DMCC bill is it's both extremely broad in its scope, and I can go into why the provisions are extremely vague for the moment and could cover all sorts of business conduct, including legitimate business conduct. So you have that breadth on one hand, but on the other hand, you don't have the compensating high level of judicial review that you would want to have when you entrust a regulator with such power. And Corey says, well, it's good. The CMA is a very technically proficient regulator. I don't think that the experience of competition enforcement in the UK, in the US, or in Europe suggests that even really technically proficient enforcers should be given that level of discretion.
So, just so we sort of, as a headline now, say yes or no, because we can, as I say, we can pick this up later on. But your argument, as I understand it, is that you're saying if we were to more tightly curtail the remit of the regulator, then JR is acceptable. If, on the other hand, there's the potential for regulatory creep, then we need to look at a different appeal mechanism.
I think the broader the remit, the tougher review mechanism.
I'm sure my colleagues will very much want to pick that up a bit later.